must be asked 3 times a week by clients and by potential clients and callers if they can sue their employer in negligence if they get hurt on the job. The answer 99.9% of the time is no, you cannot sue your employer. There's a good reason for that. Arizona has a no-fault workers' compensation system, and that's like most jurisdictions. The vast majority of jurisdictions follow a no-fault system like ours. That means if you're injured on the job and your injury arises out of and occurs in the course and scope of employment and the injury is by accident, you're entitled to workers' compensation benefits only. Those benefits are 2 types. Every case comes down to 2 types of benefits. Medical benefits, and that means medical costs are paid with no copays and no deductibles, and indemnity benefits. Indemnity benefits are actually the benefits that are paid to you as the injured worker. These are paid at 2/3 of your average monthly wage. There are maximums on that figure. Those maximums go up every year. They're indexed according to the Consumer Price Index. With that said, you can't sue your employer in negligence because workers' comp is the exclusive remedy if you're injured on the job. There are certain exceptions. If your employer is uninsured and you elect to proceed civilly against the employer, you can waive workers' comp. However, there are lots of complications with that. I have not personally seen a situation like that in at least 10 years. I haven't seen one of those cases where people will waive comp and pursue civilly. Once they filed a civil claim, once they filed that complaint, they waive their right to workers' compensation benefits. On the flip side, once an individual accepts workers' compensation benefits, they waive their right to file a civil suit. So I don't see that election much. The other thing, some folks will research on the internet and note that you can sue your employer if your employer intentionally injures you. However, in the state of Arizona, that intent has never been found. In cases going back to the 1950s, in fact, a case where an employer intentionally injured his or her employee has never been decided. That law doesn't exist. So practically speaking, in most of these cases, workers' comp is your exclusive remedy. The other thing to understand, there is one more exception, and that's if you're injured by the negligence of a third party while you're injured on the job. If so, you can file a workers' comp claim. You can then sue the third party, and that's a party not affiliated with your employer at all. You can sue them in negligence. If you get a recovery from that lawsuit, the industrial insurance carrier has a lien on any monies that are paid. The industrial insurance carrier gets all of their money back, basically, or most of it. That's medical benefits and indemnity benefits that we talked about earlier. So in short, it's very difficult to sue your employer in negligence. That's essentially impossible. Third-party cases do exist. They're more common, but in most workers' compensation cases, you will not be able to sue your employer in negligence.